Former US President Donald Trump has raised the prospect of using the Alien Enemies Act, which is a centuries-old law, to expedite deportations if he returns to office. This proposal targets undocumented immigrants as part of an anti-immigration agenda he's promoted throughout his campaign. The act, dating back to 1798, has been invoked only during wartime and raises significant legal and logistical challenges if applied to the current context. The Alien Enemies Act allows the United States President to detain, relocate, or deport non-citizens from enemy nations during wartime. Passed in 1798 amid tensions with France, it was part of the Alien and Sedition Acts under President John Adams. At that time, the act targeted non-citizens who were citizens of enemy nations and thus considered threats. Since then, it has only been invoked during declared wars, such as War of 1812, the First World War, the Second World War, when citizens of enemy countries such as German and Japanese nationals were interned. The act remains law, but unlike other Alien and Sedition Acts, it has no expiration. Although it was amended in 1918 to include both men and women, its applicability is limited to periods when Congress declares war, which is a rare occurrence in modern United States history. The Alien Enemies Act has a limited track record with only 3 major uses. The War of 1812, where British nationals in the United States were required to register and report personal information. The First World War, where over 6,000 German nationals were detained under the Act. And the Second World War, where the law allowed for internment and surveillance of Japanese, German, and Italian nationals, although most Japanese internments occurred under different legal provisions. In each case, the act was only invoked in wartime and typically involved a large-scale detention of individuals from declared enemy states. Trump recently discussed Operation Aurora, which is a plan he claims would remove gang members among undocumented immigrants. Named after a Colorado town he alleges is overrun by Venezuelan gangs, a claim that local officials dispute, this operation would focus on undocumented gang members. Trump argues that invoking the Alien Enemies Act would legally empower him to remove those he considers national security threats. His vision extends to eliminating sanctuary cities that limit cooperation with federal immigration authorities, claiming this plan would allow him to bypass local resistance to deportations. While this rhetoric appeals to his base, experts say using the Alien Enemies Act in this way poses numerous legal obstacles. The Act's wording specifies that it can only be invoked when the United States is at war with another nation. Steve Laddick, a law professor, notes that the US has not declared war since the Second World War, making Trump's proposed use legally tenuous. Further, any attempt to define migrant gangs as foreign enemies would likely be challenged in court, especially since the act has not been used in modern peacetime. Historically, courts have been reluctant to interpret laws in ways that stretch the original intent, and redefining an immigration issue as a war threat could be viewed as unconstitutional overreach. Additionally, experts emphasize that the federal government already has legal authority to deport undocumented immigrants without the Alien Enemies Act. A lack of resources rather than legal authority has constrained past administrations. Funding for immigration enforcement remains a central hurdle, as shown by failed bipartisan attempts to increase border security funding, which Trump opposed. If Trump were to attempt this unprecedented use of the Alien Enemies Act, courts would likely intervene, questioning its applicability during peacetime and requiring him to justify his interpretation of enemy. The courts might also view the act's invocation as excessive given existing deportation laws. Catherine von Ebright from the Brennan Center for Justice points out that the act's ambiguity leaves room for judicial challenges. Even anti-immigration advocates have noted the difficulties of using the act without a declared enemy state. Ultimately, experts argue that using the Alien Enemies Act in this way is unlikely to succeed in court and would not address broader immigration enforcement issues, which require resources, not new legal frameworks. Even anti-immigration advocates have noted the difficulties of using the act without a declared enemy state. Ultimately, experts argue that using the Alien Enemies Act in this way is unlikely to succeed in court and would not address broader immigration enforcement issues which require resources, not new legal frameworks.